Jay Sekulow is one of the president's personal attorneys. He joins us from Washington. Good morning, Jay. I want to start with the special counsel found no connection between the Trump campaign and the Russian interference activities. But on the question of obstruction, he chose very specific language, and I want to get your thoughts about that.
Sure.
He said that while this report does not conclude that the president committed a crime, it also does not exonerate him. He didn't have to use that language, and the Attorney General didn't have to reprint it. What do you make of that specific language?
Well, I think what it says, and this is if you understand the internal workings of the Department of Justice, this will make sense. So he issued a series of facts and then looked at the law and said it raised difficult questions of law and fact. Well, you don't bring a charge on difficult law and facts unless you get approval that theory of law would be correct. So what he did, which was appropriate under the Department of Justice guidelines, he went to the Office of Legal Counsel, because remember, Bob Mueller's part of the Department of Justice, unlike an independent counsel. And he went to the Department of Justice for the Office of Legal Counsel and the Deputy Attorney General, and they reviewed these difficult questions of law and facts as they were described by the special counsel, and made the conclusion that was not an obstruction of justice. There was no underlying crime being obstructed, and there was not sufficient evidence for an obstruction claim. And that's why at the end of the letter, the Attorney General says that in consultation with the Office of Legal Counsel, the Department of Justice, and the Deputy Attorney General of the United States, that conclusion was reached. Meaning that the Attorney General's, the Department of Justice position is there was no collusion and thus no obstruction.
Right. That's the position the Attorney General took. But this specific language, and the reason this is important is the president's claimed exoneration. The special counsel could have done everything you've suggested, but not used that specific language. And so that's what seems puzzling here. On the one hand, the president claims that he was exonerated. The special counsel, accepting everything you've just said, nevertheless chose to use very specific words, which is that he does not exonerate him.
Well, no, but he also said that he was making a finding of a violation of criminal law, which is a very important statement here. So what did the special counsel say? They could not conclude there was a legal violation. In other words, a case that they would have moved forward on. So they put it up to the Department of Justice because that's the reporting authority for the special counsel of the United States. That's how it works when you appoint a special counsel under DOJ guidelines and regulations. That's how this moves forward. And they made the determination. In other words, Bob Mueller wanted the Department of Justice to make the determination because that becomes a question of policy for the Department of Justice of what does and does not constitute an obstruction of justice. And here the Department of Justice, in consultation with the Office of Legal Counsel again, the Deputy Attorney General and the Attorney General made the conclusion.
Democrats are calling for the release of the full report, Jay, so that the public can weigh in and draw their own conclusions. Is the Trump administration pushing for that as well?
Well, what the administration has said, and obviously I'm speaking here as a private lawyer, is that they want as much transparency as the Attorney General feels like under the regulations he can provide. Obviously, and the Attorney General said this, there's what's called 6E material. I don't want to get too technical. That's grand jury material. There may be national security information in there that cannot be disclosed. But I think the Attorney General is going to disclose as much as he can without compromising national security. And grand jury material, if it's disclosed, what happens, that's a crime, actually. So there will have to be, that's why I think that part of the review takes a little bit longer. But look, this is a decision the Attorney General makes under the regulations, and he'll make it. I trust General Barr to do the right thing.
Well, there are questions about the Attorney General, by the way. The Attorney General, William Barr, and Rod Rosenstein, because they are Trump appointees, that they're not really impartial. Are those concerns legit on the part of the Democrats?
No, they're not, because this was, when you look at the Office of Legal Counsel and the Attorney General and the DAG, Rod Rosenstein's been in this case since the very beginning. He appointed Robert Mueller. And Bob Mueller did not make a determination of any kind of criminality on either count. On the collusion, which, by the way, was the basis upon which this whole investigation started, and you had members of the United States Congress said there was clear evidence of collusion between the Trump campaign and the Russian government and Russian operatives, and that was completely dismissed by the special counsel. Then when they had what they called the difficult questions of law and fact, they followed the policy and went to the Department of Justice, who made that determination.
Jay, the president called the Mueller investigation an illegal investigation that failed. What was illegal about it?
Well, look how it started. I mean, the investigation starts based on the Christopher Steele dossier, which James Comey himself called salacious and unverified. That was the basis upon which this whole process started. And it was started because of alleged Russian collusion. It was a counterintelligence investigation.
Wasn't it started after the firing of Mr. Comey?
No, it would the Operation Crossfire Hurricane started a year before that.
But Jay,
the appointment came. The appointment
it started
of the
when Papadopoulos, based on the Papadopoulos material, not because of the Steele dossier. That was not the initiating. That was not the initiating event. It was the Papadopoulos comments. Actually,
that's not correct. So what is correct is the dossier, and Bruce Orr testified to this, was the motivating factor to start this inquiry. It started, remember, as a counterintelligence investigation. And the end result after 2 years and, again, thousands of documents, hundreds of witnesses, 2,800 subpoenas, what did you find on Russian collusion? Nothing. Why? Because there was none, which was the position we advocated from the outset.
Jay, does the president have a message for Bob Mueller this morning?
Well, I would leave that I would leave that to the president. I will say, here's my message to Bob Mueller. I'm glad the investigation has been concluded. I'm glad that we can move forward now as a country. There's a lot of good things that can happen in Congress. I mean, I'm a big advocate of comprehensive immigration reform, for instance, and I think, the idea that there's going to be these ongoing congressional oversight hearings on something that's been delved into, and just look at the numbers: 2,800 subpoenas, 500 search warrants, 230 orders of communication records, 50 orders authorizing pen registries, 13 requests to foreign governments, and over 500 witnesses. For the Congress to go over all that again, to me, is a waste of money. It's political. Let's get on with the people's business.
All right,
that's
Jay,
the message I'd like to send.
Message received. Jay Sekulow, thanks so much for being with us.
Thanks for having me.